Sure, shut up. If you ask me a question, I can't answer while you're talking.
No, I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair.
Another threat. Wow.
You're probably going to hear more than one. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. I don't give a shit if you object. Is it clear what I said? I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two
Have you ever had a grilled cheese?
Other issues as well.
You're in contempt of court. Put him in jail.
All right, guys. Today's video features one of the most ridiculous sovereign citizens we've ever seen on this channel. This guy's ego is off the charts. He flat out refuses to answer basic questions and thinks he can out-talk. One of the best judges on YouTube, Judge Oakley. Seriously. The way he twists the law and tries to dodge responsibility is wild, but Judge Oakley, cool as ever and totally in control. Watch how he calmly but firmly puts this guy in his place. Let me know what you think in the comments. Did Judge Oakley handle this guy well, or could he have gone even harder? Rate the judge's performance 1 to 10 down below.
You're a defendant. Sit at the defendant's chair.
I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen. And
No, I'm not a sovereign citizen.
All right, sir, don't speak.
maybe I'm not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it was Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
You can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on record?
Yes.
Are you on your oath to the Constitution?
Hold on. What? Are you picking him up? That's one of the reasons I want you up here is there's a microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to
I didn't swear an oath to the Constitution.
you haven't
I took an oath that said I would follow the Constitution.
to not uphold the Constitution.
Yes. Follow the Constitution.
So you are upholding your oath to the Constitution.
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights and
I would have nothing less. Now, are you representing yourself today?
I'll present myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All
I,
right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Okay.
So, with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine.
so today,
You have a jurisdictional argument you want to make?
what I I served notice.
Sir,
on
it's a
jurisdiction.
yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or
multiple-
no?
Here's the thing with sovereign citizens. They constantly twist courtroom rules like they're acting in some bargain bin legal drama. It's exhausting. Now, let me be clear. I am not a sovereign citizen. But if I were, I'd at least show a little respect in court. These people walk in like the law doesn't apply to them, then act shocked when the judge doesn't play along. Answering a simple question shouldn't be that hard. But nope, they act like it's a trap. It's not ego, it's delusion, and it helps no one, least of all themselves.
Why are you forcing me to say ask?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do. Yes.
Then make it. What's your
Okay,
jurisdictional argument?
I'm presenting myself. So I need to know. Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under.
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work
Criminal
under the authority
or-
of the state of Michigan.
what is it under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is
in
not
order-
admiralty.
What
And
is it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory. That is what civil.
No.
So what is it? For the
My
record, I need to
jurisdiction
have
is
that
both
on-
civil.
I can't defend myself unless I have it on the record. Is it?
My
There's
jurisdiction.
only two.
Sure, shut up. If you ask me a question, I can't answer while you're talking. My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today under which one is
This is
the-
a criminal case.
okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. You don't say
All
statutory.
right, then you can appeal
Constitution.
my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right. So if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party.
Guy actually says there has to be an injured party for the case to be valid. Like, ... What? Newsflash. In criminal law, the state is the injured party. Breaking the law isn't just about hurting an individual, it's about disrupting public order. That's why the judge said, the people of Michigan are the injured party. Don't need someone limping into court yelling, he got me. It's not how it works. That's like robbing a bank and saying, well, unless the vault presses charges, I'm innocent. So what do you think? Is this guy clueless or just wasting everyone's time on purpose? Clip for this is exactly why I respect Judge Oakley. The way he handles sovereign citizens? Chef's kiss. He doesn't let them hijack the courtroom. And he's not afraid to call out nonsense. Some people in my last video said he was being too harsh, but honestly, I disagree. Sometimes firmness, even sarcasm, is exactly what's needed to keep these courtroom clowns in check. The alternative? Let them turn every hearing into a circus? Nah, we need more judges like Oakley holding the line and not letting legal theater stall actual justice. Let me know, do you think the judge was too harsh or perfectly just?
Let's dive back in and see if this idiot can top his own nonsense.
Who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing
state?
the charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the name. Would you mind putting your name on the record?
She's a witness. She is a
I-
witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What I'm supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Steffen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611B, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause. I just
This is a problem. This is a preliminary exam.
this is okay. So right here, it
This
says,
is the probable cause hearing.
It says it's,
All right,
it
stop,
says-
stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal
I
objection
also-
is.
I'm also objecting
What is
to-
your legal objection?
to not waiving my probable cause hearing.
Denied. That's admitted.
At this point, I wish we could see this guy's face, because the confusion he has over something as simple as a probable cause conference is baffling. It's not rocket science. It's just a step to determine if there's enough evidence to move forward. But this guy acts like he's prepping for the bar exam instead of a basic court hearing. And don't even get me started on the grilled cheese moment. Judge Oakley tried every way possible to explain things simply and somehow landed on grilled cheese as a metaphor. Honestly, iconic. Do you think this guy is genuinely confused? Or playing dumb to stall the process? My guess, bit of both.
Under what grounds am I denied not?
Because
have
you
my
didn't
due
give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objections.
object
to the evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing, and I did not.
They're the same thing, Mr.
It's
Michaud.
still on this. it
Mr.
doesn't-
Michaud.
it
They're
doesn't-
the same thing.
But it's still. I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different date that says preliminary.
Have you
exam.
ever had a grilled
If it
cheese?
was different,
Have you ever
if-
had a grilled cheese?
if it was different, why would it have two?
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have
I'm-
two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way. But my goal was just to be able to conduct a
That's
probable
fine.
cause conference where we were going to find out if there was any offer, whether What discoveries
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today. So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? If this is a hearing, or
You
a conference,
didn't
right,
waive it.
so
There's nothing to
do
hold.
I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference. And in order
There's
to
no
prepare,
preparing for a probable cause
It's-
conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this.
This hearing should have been wrapped up in 10 minutes. But here we are, watching this guy turn it into his personal TED Talk. Sovereign citizens always act like the judge is their personal legal consultant, demanding explanations they should already know or at least have asked their lawyer about. This point, it feels like a full-blown condition. Judge Oakley is doing everything he can to move the process forward. But this guy just won't stop interrupting. Honestly, it might take a night in jail to snap him back to reality. What do you thinks it time for the judge?
Do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today. He ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, in circuit court. So if he wants to sort of move forward on that defense alone, that the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some. I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served the notice that I requested the criminal bond information. I requested
Criminal
the
what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have the affidavit.
There is no bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me.
Well,
And think
okay.
listen to me, sir. I am not going to let you interrupt me.
No, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay? That's just the way it works. My courtroom, I get to decide how it's run.
And boom, 30 days in jail? If that's not a wake-up call, I don't know what is. Let this be a lesson. If you're walking into court thinking you're a legal genius, maybe take a step back and hire an actual lawyer. Any lawyer. Someone who knows the difference between real legal arguments and TikTok conspiracies. All this guy had to do was answer basic questions, and he could have walked out. Instead, he chose to play games and lost. Hard. My favorite part, when Judge Oakley made it crystal clear that yes, he is the person named in the case, because you know he showed up to fight it. Doesn't get more obvious than that. So what? Do you think was Judge Oakley too harsh or just right? Personally, I think he nailed it. Drop your thoughts in the comments. If you enjoyed this breakdown, hit that like button and subscribe for more courtroom chaos. Appreciate you all. For watching, see you in the next one.